So welcome everyone. I'm Lindsay McPhail, the HR generalist here at Innovate HR. And today we're going to be talking about two new employment laws. So Kirsten is here as well with me to help keep me on track. But before we get started, I've got a question for you, Kirsten. So
Okay.
Kirsten, all
I'm
right,
ready.
are you a lawyer?
No, I am not a lawyer.
Well, guess what? I'm not either. So I have to start off with my disclaimer that this presentation is intended to be general information only and does not carry the force of legal opinion. I'm not an attorney, but as your human resource partner, I'm providing this information as a service with the purpose of training our managers and on-site staff about the new laws. I have attended many trainings regarding the Pump Act and PWFA over the last few months, but these are still very new and the EEOC is continuing to update their guidance. So there's not a lot of case law for us to look at and use as examples, but my understanding of the regulations is based on the training materials directly from the government agencies and legal interpretations from attorney webinars. But again, I am not an attorney, but I am training today on what managers need to know based on what's publicly available on the EEOC website. So with that, we will get started and jump right in. So why is this something that we need to talk about, and why did the Equal Employment Opportunity feel that these protections under the Pump Act and Pregnant Workers Fairness Act were so important? I think it's good to know that women comprise almost 50% of the US workforce. And 75% of women will be pregnant and employed at some point in their careers. So again, that is why it is so important for us to talk about these laws, because as we know, it does impact a lot of our employees. And it's that important, especially with the labor market as it is now, turnover rates, and how hard to fill vacancies. That's making these accommodations will be beneficial for both you and your employees. So what's been practiced when it comes to expecting a new mothers in the workplace? More than 30 states and cities have existing laws that provide accommodations for pregnant workers. So a lot of you might be asking, what's all this fuss about if your company already makes these accommodations for your pregnant workers? South Carolina specifically has the South Carolina Pregnancy Accommodations Act and the South Carolina Lactation Support Act, which pretty much covers the same protections that the Pump Act and the PWFA provide. And again, over 30 states already have similar regulations in place, but there are areas in when the Pump Act and PWFA are a little different, where their terms are a little broader and what can be an accommodation and what can be considered an undue hardship is different. So some industries might be more impacted than others who have agricultural workers, nurses, retail associates, and line workers. For some clients, this might not be a big change, but for others, this will be something new if you have to get used to having pregnant workers and abiding by these new regulations, because now that this is a federal law, it covers all states, not just the 30 states that previously had similar regulations. And there are other federal laws that come into play here that we'll talk about throughout the presentation, like Title VII, the ADA, and FMLA. Right. So today we're going to be covering the Pump Act, since we're going to start with the Pump Act since it was enacted last year, and most of our companies are already used to providing these accommodations already. Then we will talk about the Pregnancy Workers Fairness Act and how reasonable accommodations and undue hardship might differ here than with ADA. And we will end with a series of scenarios to talk through, including examples for both. We're going to be breaking down a lot of information for how employers should work with the new laws. So I'm sorry this won't be a fun and exciting training for you, but I hope you can take away the importance of accommodating your pregnant workers and share this with your team and other managers who aren't attending the webinar today. So again, I'm Lindsay McPhail, our HR generalist. So Kirsten, do you think you've got a kind of a good understanding of what we're going through this afternoon?
You and me?
Yep.
Yeah,
Or-
I'm excited. We want this to be interactive, so if you guys have questions, feel free to jump in and ask questions. But we're definitely excited to cover this information with you guys.
Kirsten is going to be covering the chat feature for me. So if you have any questions, please go ahead and put them in there and we'll make sure they're covered. There will be a question section at the end as well, where we can talk about anything. And of course, anytime after this, if you have particular scenarios you want to talk through, we're always available. So on December 29th, 2022, President Biden signed the Consolidated Appropriations Act into law. In this act, the law includes the Pump Act for nursing mothers, which extends to more nursing mothers, it extends more rights to nursing mothers to receive break time and a private place to pump at work. The FLSA requires employers to provide reasonable break time and a private place to work other than a bathroom for an employee to pump breast milk for their nursing child for 1 year after the child's birth, each time the employee has a need to pump at work. So the key word here is each time. The frequency of breaks needed to pump at work, as well as the duration of each break, will likely vary. Many women have different needs to pump. Some might pump more frequently than others. Some might take longer than others. So you must go by what the employee tells you her need is. As with other breaks under the FLSA, the nursing employee must be completely relieved from duty, or the time spent pumping must be counted as hours worked for the purpose of minimum wage and overtime requirements. But if an employee already provides break time, it's important to know that if there is a paid break time and the employee chooses to pump during that time, they must be compensated in the same way everybody else is during that break time. So as we know, nursing mothers should be provided a space that is shielded from view, free from intrusion, from coworkers and the public, and may be used to pump breast milk. So this cannot be a bathroom. The location must be functional as a space for pumping milk. An employer may temporarily designate a space or make a space available when needed by the employee. So you can take a conference room and lock it, and that would be considered a private space for that employee to pump, as long as nobody else is coming in and intruding on her privacy. Employers should take into consideration the number of nursing employees and their schedules to determine whether more than one space should be needed at a time. There might be necessary to have a set schedule or work with multiple employees and to trying to schedule their pumping time around each other for coverage as well. So when we say that the Pump Act only applies to employers with 50 or more employees, that doesn't mean that employers under 50 shouldn't provide pumping breaks for nursing mothers. It just means that an employer that has fewer than 50 employees is not required to provide break time or space only if it proposes an undue hardship. The employer must demonstrate that compliance requires significant difficulty or expense when considered in relation to the size or financial resources, nature, or structure of the employee's business, not available to employers for 50 or more employees. So if you have more than 50 or more employees, this undue hardship really doesn't count, or it is likely not going to. All employees who work for the employer, regardless of a work site, are counted. So it doesn't have to be 50 employees in one location. It's 50 employees total in your company, wherever they are located. So Kirsten, do you have any thoughts on the Pump Act before we move to the Pregnancy Workers Fair Act?
Yeah, so what if I have a front desk at my business and we plan everyone's breaks and lunches around coordination of that front desk? And one of my employees who needs to pump is supposed to be covering the front desk. What do I need to do? What is my job as an employer to ensure my business is taken care of, but I'm also following this law as I should be?
So if the employee who's supposed to be covering that front desk needs to pump, we have to find an accommodation to allow that employee to pump in privacy. So whether it's coordinating that coverage with somebody else during the time that she would normally pump, it's having that conversation with her to know when are you, what is your pumping schedule generally, so we can plan ahead. It's all about communication. And if it is going to interfere with the time that she is normally scheduled to sit at that front desk, then you may have to reschedule people around so then that she can pump. Because again, when an employee says, I need to pump, we have to allow that each time that they say that they need to pump.
Okay. What if I have an employee that has to pump every hour or every 30 minutes and I walk by the pump room and I hear her talking on the phone or I hear her listening to YouTube? What can I do as an employer if I feel that she is not pumping or not being truthful in her pump schedule?
That's hopefully a very exaggerated situation, that somebody would have to pump that often. And so again, I think it's having that open communication with the person to understand what their pumping needs are. Again, some people might just pump twice a day, but they need a longer break. There might be others that pump 4 times a day for a shorter break. It's understanding that. But in the event that you're questioning if an employee is really pumping or not, remember that if they're not doing work, and they're taking that break, it doesn't have to be paid. If they're on YouTube, if they're pumping, can they do that at the same time? If they're talking on the phone and they're pumping, can they do that at the same time? So I think we have to just have that trust relationship between employee and manager to know that our employees are accurately using their time when they're saying that they're pumping. And if there tends to be an issue to come up with that, that's definitely where we can be involved and try to help manage that situation.
Okay. I have a few more questions. Do we have to provide any type of refrigeration for employees? Is that required under this law?
I believe that is required under this law. I didn't get into too many details under the Pump Act in this presentation today, just because it has been in effect for a while. We can definitely dive deeper if we need to, but I wanted to make sure we got into the new reasonable accommodations under the pregnancy. So that is a good follow-up, but there are other stipulations than what we just covered under the Pump Act that sometimes you do have to provide as employers. Obviously, the ability to pump when they need and the private space to pump are the main two aspects of this act, but there are some other stipulations.
Okay, awesome. Thank you.
And great questions. We have some scenarios at the end, and I think you asked some hard ones because the ones at the end are directly from the EEOC and the FSLA. So I'm glad to have you here to help me. All right, so now we're going to jump straight into the PWFA. And the Pregnancy Workers Fairness Act. It was signed on December 29th, 2022 as part of the Consolidated Appropriations Act of 2023. And it was effective as of June 27th, 2023. So again, different from the Pump Act. The Pump Act was effective at the very end of the year last year on December 29th, where this became effective later and is now effective as of June 27th. This applies to employers with 15 or more employees, and this borrows concepts under Title VII and the ADA and requires accommodations for pregnancy-related conditions, but with important distinctions. So existing laws make it illegal to fire or otherwise discriminate on basis of pregnancy or related conditions, and may require an accommodation in some circumstances. Regulations from the Equal Employment Opportunity are on the way, but it is the Act's primary goal to keep pregnant workers working and earning income while staying safe and healthy on the job, providing economic security and the health and safety of the mother and baby. So again, that's important to remember why these laws exist. So under this act, employers must make a reasonable accommodation to the known limitations related to pregnancy, childbirth, or related medical conditions of a qualified employee unless such covered entity can demonstrate that the accommodation would impose an undue hardship on the operation of the business. Again, this is directly from the law, but now let's break down some of these terms. I'm going to start with a reasonable accommodation. A reasonable accommodation is defined here the same way as it is under the ADA. So managers should be familiar with this already, and it's good to know that there's that similar process of what a reasonable accommodation is, but what's different here is sometimes what's considered an accommodation, and that we do have guidance about what those accommodations can be. And like the ADA, there isn't a magic word an employee has to say in order for them to ask for an accommodation, especially with pregnancy. It's a known limitation. And under the PWFA, there is an expectation that you can and must make an accommodation. But if you hear, due to my pregnancy, or following my miscarriage, or because I recently gave birth, or related to my gestational diabetes, if you hear that from an employee, what comes next could be a request for accommodation, so don't dismiss what they're asking. And additionally, undue hardship is defined the same under the ADA, significant or difficulty expense. However, under the PWFA, according to the interpretations that I've read, undue hardship is not a defense when it's a temporary accommodation. We'll see this more in some of our scenarios, but they said undue hardship should only be used when it can be litigated. So we need to explore all the accommodations possible through the interactive process before we get to this point of claiming undue hardship. All right, so now we have the essential functions and what is a qualified employee. And we need to note Another difference between the ADA and the PWFA is that qualified employees are considered even if the employee cannot perform an essential function temporarily. This is a big difference from the ADA. Because the essential function can be performed in the future, just not at this moment due to the pregnancy, an accommodation can be temporarily removed as an essential function. So on the screen, we have it listed exactly as it is stated in the law, but it is something that's new for us to remember, that we can temporarily remove an essential function to provide an accommodation for an employee. Temporarily. So how can these requests be made? Or how do employees go about requesting an accommodation? We should know that requests can be informal. Written requests aren't required. For example, a pregnant worker who is in the last trimester of their pregnancy, who usually stands to do her job and requests a stool to sit on. In this case, the worker's pregnancy is likely known to the employer or readily apparent, and the solution is inexpensive, readily available, and depending on the exact nature of the job, it's minimally disruptive to the employee's operation. So if this is an easy request that you can easily accommodate, but if the request isn't something that you can easily or immediately accommodate, we must go through the interactive process. We strongly recommend that the employee send us an email with the request or limitation that they're having. If they have a doctor's note, they can go ahead and send it. If they don't have a doctor's note, we might send a fit for duty form asking the doctor for those limitations. However, because pregnancy is a known limitation, some things just make sense for the health and safety of mother and child, and a doctor's note might not be needed. But we will navigate that process for you and work through the accommodations, all the accommodations possibilities. We will, of course, go through our regular process with any LOA or ADA and work with our client contact to help make the determination of what's reasonable or not. So again, they can be informal. They aren't always going to be written. And there is a lot of information out there on the internet, on the EEOC website, a lot of training. We have this poster. We've put all these posters in the timekeeping system. So employees who are going through this they're gonna have their own roadmap as well that they're following. So if it's a request that the manager can't handle, then that's when you ask them to send that to Innovate. So there are some things that we have to make sure we don't do. This is the list of employment practices that are unlawful and that we need to be aware of. We cannot force leave for pregnant workers. Requiring a qualified employee to take leave, whether paid or unpaid, if another reasonable accommodation can be provided. So leave is going to be our last resort. We cannot force an accommodation to an employee or just give them one option as an accommodation. Requiring employees to accept an accommodation other than a reasonable accommodation arrived at through the interactive process. So again, if there's not an easy accommodation right off the front, we have to go through that interactive process. And we cannot retaliate employees who are pregnant or who are asking for an accommodation. Taking adverse action in the terms, conditions, or privileges of employment against a qualified employee on account of the employee requesting or using a reasonable accommodation, or coercing, intimidating, threatening, or interfering with any individual in the extra law, or because they exercise their right under the law or because they aided or encouraged another individual in the exercise or enjoyment of their rights under the law. So what do we do if we can't accommodate their request? Again, if an accommodation isn't easily identified by the employee and manager, then we will need to begin the interactive process, and that's when you should call us and we can guide this process. The interactive process is simply means the employers and the employees with disabilities who request accommodations work together to come up with an accommodation. So once an employer has been made aware of a known limitation related to pregnancy, childbirth, or related medical condition, the employer will be required to engage with the employee in the process of identifying a reasonable accommodation. In some cases, under the PWFA, the worker will request an accommodation that will easily be addressed, and we won't need to do the interactive process. But in the event that we're in that interactive process, we will brainstorm possible accommodations and go back and forth between the employee and the employer to see what works best for both parties. Our approach here is to think about the goal, not the problem. And the mindset that we need our managers to have is, how will this work? Not, this can't work. I apologize, I keep losing my mouse to move forward. So now let's talk about some potential accommodations. We have the ability to sit or stand, the ability to drink water. You know, maybe employees need to walk around with a water bottle where they normally wouldn't be allowed to on the line. Have closer parking, more flexible hours. You know, if they have a complicated pregnancy where they can do their job, but they might need to go to the doctor more often for some checkup appointments. And maybe they don't have the time, the PTO, to cover that, but we can make an accommodation to let that happen. Appropriately sized uniformed and safety apparel, if there's things that they have to wear, that now we have to get a different measurement for them. Additional break time to use the bathroom, eat, or rest. And time off to recover from childbirth. A lot of times this is covered under FMLA, but in the event that an employee doesn't have FMLA and doesn't have short-term disability, PTO to use, or if your company doesn't have a real maternity policy, they now are covered under this as a recovery time. And then be excused from strenuous activities or activities that involve unsafe exposures. So this list is not exhaustive of all the possibilities or a way to make an accommodation for a pregnancy work for your team. It may also include temporarily trading duties or swapping jobs with somebody, temporarily removing an essential function of the job, which we talked about, or assigning light duty. And even accommodation can be hiring attempt to help with heavy lifting or specific tasks that are limiting to the employee. Again, remember, this is because it's temporary. So what happens if you deny an accommodation or forced leave? The employee then can now file a claim with the EEOC. So what are those damages look like? They're the same as Title VII or what would happen under ADA if we received a claim. It could be back pay, compensatory damages, past or future emotional distress, punitive damages, attorney fees, and cost. There are caps based on your employer size as to what those damages could go up to. But it is something that's important and again new, because as of June 27th, the EEOC is now accepting claims for violations of this act or retaliation for pregnancy accommodations. So what we can do here is make sure that we have a good faith defense. As long as we show that we have gone through the interactive process, we've discussed all the possibilities of accommodations and how they would work or might not work. If as long as we know we've done that and an employee still doesn't like the outcome or feel like it worked for them and they make a claim, as long as we're showing that good faith defense, then we have a case here. So again, that's why we are here to help you, and we're documenting everything and we're making sure we're following all these steps. So what now? So updates have been made to most of our client handbooks, to either the accommodations policies or specific new policies for new and expecting mothers. Now, some of our clients already had this in their handbook, so there wasn't a ton to update. And there's a few clients that we have to get to as well that haven't been posted yet. But if we will be making sure all of our policies are updated to follow the new policies. But with your team, we want to make sure that y'all discuss the process when an employee requests an accommodation due to pregnancy limitations. The policies do say when they have a need to make that request with their supervisor. Again, if it's something that the supervisor can't immediately approve, then that's when it becomes something that we go through the interactive process for. So we need to train your managers and supervisors, whether that's in a team meeting that y'all are having at work, whether you send them this webinar or just make sure that they know of the posters and the new law. But your managers do need to know that accommodations need to be made. So there are posters available in the timekeeping system under the document section. And always remember that we have to engage in that interactive process and document it. And I cannot stress more the mindset that we need to have, our clients need to have, our managers need to have. It's how can we make this work? Not this will never work. Here's some quick tips and things to remember. That undue hardship is a high burden and will be very difficult given the temporary nature of pregnancy and related conditions. So again, we really need to try to make an accommodation work. Leave is the last resort if an employee is able to continue working. So if the employee wants to work and just has an accommodation that they're requesting, we can't just say, well, we're just going to start your FMLA time. We need to go through and find an accommodation that will work. That's good for the employee and good for the employer. Protections don't end at birth. Limitations related to childbirth and related to medical conditions are also protected. And that's even including pumping. So this is where now the Pump Act carries over into the Pregnancy Workers Fairness Act. And even so, employers that are under 50 kind of still follow here in regards to pumping. We got to make an accommodation or we got to try. So when determining whether an accommodation presents an undue hardship, or consider when similar accommodations are provided for a religion or disability. And that just means if we're giving accommodations already to other employees who are under ADA or another disability, we now have to do that for our pregnant workers if they're asking for an accommodation. Previously, pregnancy wasn't always covered under ADA, and so that wasn't always the case, but now it is. If we have light duty in place that we're already giving somebody else or would give somebody else with another disability, we now have to do the same thing here. And remember the difference between leave for medical reasons and bonding reasons, and consider Title VII obligations to new birth parents. All right, so now we're going to go over some scenarios. And again, these are scenarios from the EEOC training. So they are kind of recommended scenarios to talk through, and most likely they are recommending that these are all scenarios that should have a reasonable accommodation. So we're just going to talk through them and understand what they look like. So the company hires Elise on May 15th, 2023 into an outside sales position. 2 months after her hire, she informs HR that she is pregnant and is having issues with morning sickness. Elise asks that she be permitted to be scheduled and attend all morning meetings virtually. Elise says this will only be needed until her morning sickness subsides, which she hopes will only be in a couple of months. HR consults with Elise's manager about the requested accommodation. The manager is concerned about Elise's ability to cover her territory and meet her quotas if she doesn't leave the house before noon. So what issues should we consider? There's no limitation that she's pregnant. She's told us that she's pregnant and she's let us know that she's going through morning sickness. Is this qualified with an accommodation? So she's saying, even though she's in a sales position, that she'd like to not leave the house in the morning to make her sales calls, but will do so after that. But this is only for that morning sickness time period, which is not the full 9 months. So after that morning sickness is over, she'll be able to do her full rotation again. So would this be considered qualified as an accommodation under the PWFA? It would be, because that pregnancy morning sickness is temporary. And so we can then say, well, we're now reducing that schedule of her doing sales calls, but she's not missing any meetings that are already scheduled in the morning. There are going to be concerns about coverage and territory and meeting quotas, but this is something that kind of has to be considered. So Kirsten, do you have any thoughts about this situation?
I do, but I will say Randy jumped into the chat and he said, I would say that since it's a limited time, that this would be a reasonable accommodation.
Yes.
And I would agree with Randy. I think he's right.
Right. Great job, Randy. So can we require Elise to give us medical documentation? What do you think?
Randy's typing. Let's see.
I'll go ahead and jump in and say, yes, we can.
Okay. So Randy's thought is no, pregnancy is an obvious condition and morning sickness is a known part of the process. That's his approach.
So that would be the recommendation is that we wouldn't have to necessarily get medical documentation for this. However, we can, we as employers and as an HR, that we would be the ones to ask for documentation if there was a real need for it. So maybe in this situation, we wouldn't, but it is a possibility that we could, but we would not the managers. But I like where your head's at, Randy, because obviously we know she's pregnant. She told us she's pregnant. We don't need to have a doctor to say yes, and she has morning sickness, because again, not all employees are going to have the same type of pregnancy, but we have to go by what they are telling us, just like pumping. Every employee is different, and we have to go by with what they tell us and take that as face value. And that part is the same as the ADA. We have to take what they tell us at face value. Okay, so here's another scenario. Irina, a shift manager at a fast food restaurant, takes 4 25-minute pump breaks each day when she first returns to work after the birth of her child. So is this an acceptable pumping schedule, or how should the employer manage around this? Kirsten, why don't you give
Yeah.
me your thoughts?
So in my thoughts, I think that this is acceptable. I think that the manager would just need to understand what her schedule is. So if, she kind of has a consistent schedule when she pumps based on these 25-minute breaks that she needs, I think that's something that they could accommodate other employees' schedules around for coverage of their restaurant. I think they need to make sure that they have a safe place, or a place that's not the bathroom, where she can go and pump, that has a lock, where no one will interrupt her during that time.
Great. And I think there's one thing that we haven't talked about yet with pumping, is that employers have noticed that they're going to need to adjust the schedule, right? Because we know when the employee lets us know that they're pregnant, we know when they are out, and we know when they're going to return. So we also kind of need to anticipate that coverage if we think coverage is going to be an issue for their pumping breaks. But this is an example under the FLSA of an approved pumping schedule. Okay, Kirsten, I'm going to let you read this one. I'm sure everybody is tired of hearing me talk. And then just go ahead and read it straight through, and then we can work through it.
Okay. It is July 2023. Katie is a retail associate. Her job duties include assisting customers, unloading freight, and stocking shelves. During the last trimester of Katie's pregnancy, Katie's midwife restricts her from unloading freight and stocking shelves, which her employer considers to be essential job functions. How should the employer respond? I know one thing that sticks out to me. So under the Fairness Act, essential job functions do not come into consideration like it does for ADA. So that's the first thing that jumps out to me. And because we know this is a limited or temporary, because she's in her third trimester, I think it would be best for the employee or the employer to accommodate this. Maybe she can help answer the phone. For example, if this was like a Walmart, right? They have someone that answers their phone. They also have people that stock shelves, unload freight. So there could be another accommodation that they could provide her, that maybe not no lifting and things like that.
These are all great. And so that's definitely things that to consider. Can she still assist customers? Likely. But unloading the freight and stocking shelves, maybe she's switching duties with somebody else temporarily. Maybe we're giving her light duty assignments and just not even scheduling her for this shift at all, and just kind of changing what she's doing. But again, that's temporary. So you hit it right. She's in that last trimester of her pregnancy. So we know this is coming to an end. So this is a very temporary accommodation that we're having to make. And by making these accommodations, it is making making the accommodations is making it safe for her at work. And again, we want to make the pregnancy safe and healthy and keep the employees working. All right, so we have a few more scenarios. These are quicker, not as long, and then we'll end with some questions. A pregnant delivery driver asks for light duty work because they cannot lift heavy boxes because of their pregnancy. The employer has a light duty program for workers with on-the-job injuries that excuses them from lifting heavy packages. So with this is like, if there's already a program for light duty for on-the-job injuries or workers' comp injuries, then we would do the same thing here. The same thing would apply for pregnant women who are asking for that accommodation to not lift.
All right. Yeah, Randy jumped in. He said since they already have the program, they have to honor the accommodation.
Yeah, that's exactly it. So Leslie, a department store delivery driver with a 9-month-old baby, needs 2 30-minute pump breaks each day she works. So I think that sounds reasonable. 2 30-minute pump breaks. Things that we need to consider that we don't necessarily know in this situation are what are already the breaks that she has. If she already has specific scheduled breaks, but those aren't times when she's ready to pump, then we have to allow her to take an additional break when she needs to pump. So we can't make people pump when we tell them to pump. Unless they can do that. And, I'm not sure. But whenever an employee says that they have the need to pump, we need to allow that. For her, it's 2 30-minute pump breaks that she can work in her day. She just needs to work with her manager so everybody knows and can work around that. I'm going to go ahead and kind of skip through. A retail worker needs 8 weeks of leave to recover from childbirth. The employee does not qualify for FMLA, and the employer does not offer short-term disability leave. The worker will be able to do the job after recovering from childbirth. So we kind of talked about this earlier.
Yeah, so this is temporary, and then based on what we talked about earlier, this also includes time for recovery. So this is why the employee would be eligible for those 8 weeks of leave to recover, and then you would be able to hold that position for them to return, since it is a temporary accommodation.
All right, so we're almost here at the end, but I can't end our presentation today without having a reminder about discrimination and retaliation. So employers are not allowed to discriminate against employees based on the fact that they are pregnant, if they were pregnant, that they could become pregnant or intend to become pregnant, they have a medical condition that is related to pregnancy, or they've had an abortion and are or considering having an abortion. We also can't retaliate under the Pump Act for the need to pump, and we can't retaliate or discriminate for a request accommodation while they're pregnant. So do we have any questions as we are ending our presentation today? I just wanted to remind everybody again that I'm here to help. Our team's here to help. As these situations come up, make sure that you give us a call and we can help walk you through it. If this is something that you get a situation that you're just not sure how to handle, again, that's what we are here to do. So does anybody have any questions now? And again, we'll always be available to answer the questions and take over that interactive process as they come up.
I think one thing to know, as Lindsay shared earlier, is that a lot of times these requests are not direct and they may be indirect. So it's training your management team to listen to those keywords and pick up on, oh, let me connect you with HR. We need to get you connected with Innovate HR. I think that's a big thing to make sure that they understand those keywords to hear for when an employee may be, indirectly requesting an accommodation.
Yeah, we definitely don't want the managers just to automatically think, no, that can't happen, and say that to the employee without going through that process. So if it is something that the manager, even if they don't think it can be accommodated, they just need to say, well, let's get in touch with Innovate HR and start that request for accommodation. All right, well, if that is it, we can go ahead and end our presentation for today. Like I mentioned before, guidance is continuing to come out about how this is going to be handled. There isn't a lot of case law for us to look at saying that this happened already with this company and this employee, and this was the situation, since this is all very new. But it is definitely something that we need to be aware of and train our managers on. So we will continue to update our handbooks and add support to your team. But if that's it, we'll go ahead and end our session today.